Good morning. Please be seated. We are here for oral argument in cause number CR170461, State versus Rodriguez. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the brief and discussed this case in conference. You can assume we are familiar with your arguments. At this point, counsel, you may proceed.
May it please the court. My name is Jamie Ashley. I'm a deputy county attorney with Mojave County Attorney's Office, and I'm representing the state. The trial court's ruling in this case should be reversed. The trial court erred when it considered the officer's subjective motives throughout the entirety of the traffic stop. The trial court erred when it ruled that consent was withdrawn. The defendant never withdrew his consent, and the officer had probable cause to conduct a search of the vehicle in this case.
Let's start with your last point first, if we could. Just because the ruling is not, from the trial court, is not as clear as it could be. What is your understanding of the court's ruling regarding reasonable suspicion for the initial stop? What is your understanding of what the court said? Because it's not entirely clear to us.
To get to kind of reasonable suspicion, the trial court, the state read it and interpreted it as the trial court made rulings that he didn't like the reason for the traffic stop, but it was okay. And then when it got to reasonable suspicion, he didn't really like it, but he applied a Daubert standard, the scientific evidence standard, to the officer needing, when really that is not the standard for reasonable suspicion, and there was no expert testimony to apply the Daubert standard. So it was the state's...
The Daubert standard would go to, what, an assessment of the nervousness, or what was the... What would the Daubert standard have to do with whether the officer saw the turn indicator and how close the vehicle, whether there were other cars in the area? Was that part of the Daubert discussion at all?
It was not part of the Daubert discussion, really. He kind of applied the Daubert standard to almost everything, from the beginning of when the officer looked inside the vehicle and saw his arm was nervous and the face was grimacing of the driver. But the Daubert standard does not apply to the facts of this case as to reasonableness. What really should have been looked at is to the officer's 12 years experience and tens of thousands of traffic stops. I believe the court erred when it applied the Daubert standard, trying to find a scientific basis as to any reasonable suspicion.
In your view, is there a specific finding regarding, does the court disbelieve the officer's testimony that the defendant did not use his turn indicator? Is there a specific ruling on that issue?
I believe the court mentioned it, but it was more of a, I don't like this, but the state can proceed even after the reasonable suspicion. So throughout, I believe the court ruled and took it as, I don't like that the officer can conduct a traffic stop for this turn signal issue, but the state can proceed. I don't like that the officer can do a traffic stop for following distance and unsafe lane change, but the state still can proceed. I don't like that the officer looked in the vehicle, but the state can still proceed.
That is the impression I got, but the sentence, that's kind of difficult. And so I don't really disagree that the officer didn't have an ability to pull over Mr. Rodriguez for a traffic violation. I don't know if that's he's misspeaking. It doesn't seem consistent with the rest of the discussion, but that does seem to be saying, I disagree that the officer had a basis to pull over Mr. Rodriguez if you get rid of the double negatives. That seems to be what he's saying there.
And I took it as, well, with the double negative, which was a little difficult to kind of sift through, but we analyzed the traffic stop, and it was kind of like he was saying, I don't like this, but the state can still proceed, and that's why we moved on to the next issue as to what he analyzed next, which was the reasonable suspicion, the VIN number, and then applying to where he ruled for consent. And the state's opinion is the consent was the only issue with this court.
Okay, so in your opinion, just to make sure we're all on the same page, an officer must have articulable, reasonable suspicion that a person committed a traffic offense to justify a stop. You believe that the trial court found that articulable, reasonable suspicion of a traffic violation?
Yes.
Okay, given that, proceed.
Okay. So, and then going back to the kind of analysis of our trial court, in the state's opinion, it's that he did go through and analyze it in a way of there was the reasonable suspicion to conduct the traffic stop, although he didn't like it. We move on to the next point, was removing him from the car and speaking to him about the travel arrangements, the trooper speaking to the defendant about the travel arrangements. And then we move on to just checking the VIN to verify the car was in fact allowed to be in possession of this defendant, and he spoke to the passenger. The court analyzed that and said, well, I don't like this, but we now can proceed to the next issue, which is going to be also reasonable, or the nervousness that the officer noted. And the court did apply, like I stated earlier, the wrong standard, which he applied the Dauber standard for a scientific analysis, which is the wrong standard in this case. We should be looking to the training and the experience of the officer and not a scientific basis, but consider the nervousness of his training and what he has seen, and considering the totality of the circumstances in this case, which goes from the beginning of the traffic stop.
So if the initial traffic stop was justified, as you believe the court ruled it was, does it matter about the nervousness, etc.? The officer was justified in pulling him over initially.
No, I think once we get past the traffic stop, which I believe was a valid traffic stop and warranted, I think we basically get to the issue of consent in this case, and that's when the officer filled out the warning, handed the written warning and his driver's license over to Mr. Rodriguez in this case, and the officer asked for consent to search the vehicle, or I apologize. The first question was, do you have anything illegal in the car, drugs in the car? And the defendant said, no, you can go ahead and check. At that time, I believe there's consent. The officer did ask a clarification question of, can I search your vehicle? To which he did state, yes, you can check it. At that time, I think there's consent in this case. The trooper then handed a consent form to search form for the defendant, Mr. Rodriguez, to read. It appeared he had read it. At that time, Mr. Rodriguez asked Trooper Callister if he could withdraw consent. Trooper Callister stated, of course, yes, and there was no withdrawn consent at that point. Trooper Callister asked a follow-up question of, well, are there drugs in the car or anything illegal in the car? And Mr. Rodriguez stated, there's a little bit. The clarification was, there's a little bit, about a gram of methamphetamine in the car, and at that time, Trooper Callister has probable cause to search the vehicle.
Does it matter whether he withdrew consent or not? Isn't it just, what if he just said, yeah, no, I'm withdrawing consent, you can't search, and then the follow-up question comes, are there drugs in the car, and he says yes. Doesn't he then have probable cause? He doesn't need consent, does he?
Correct, yes. He can withdraw consent, and then it would have to be articulated under whether there's reasonable suspicion to detain and ask a question, or whether there was a prolonged detainment, which I don't think there was in this case for the facts that were presented.
Well, even if we assume that he withdrew consent at that moment, I mean, it was one question, wasn't it? There was no additional time at the scene. It was just, do you have drugs in the car?
Correct. There was not any measurable amount of detainment at that point. It was one question to which probable cause was then gained by the officer. Do any of the courts have any other questions? Okay. I will save the rest of my time for rebuttal.
Thank you, Ms. Ashley. If you're ready.
May it please the Court. My name is Troy Anderson. I'm from the law offices of Sean Hamp, and I represent the defendant appellant in this case, Mr. Anthony Rodriguez. The trial court's determination was correct in this case because Mr. Rodriguez's rights were violated at several distinct points. If this court agrees that the trial court did not abuse its discretion and apply the wrong law at any one of those points, then the ultimate decision, the correct decision, would be to uphold the motion to suppress ruling by the trial court. Now, since there are several different parts to this case, I welcome any questions from the court, and I think I'll start by addressing some of the same questions that the court had.
You could just go straight to the, was there a ruling that there was not a basis for pulling him over based on a traffic violation, on a turn indicator violation?
Yes, there was, Your Honor, and I agree with the court that it was perhaps not as clear as it could have been. The trial court said in the very end that he was suppressing the evidence. Did not say, I'm suppressing the evidence because there was no stop and because there was no a prolonged detention. However, if we look on page 53 of the record, he says that he has problems with the stop. He also says
problems in the sense that there was no evidence to support it, or problems in the sense that he just didn't like it?
Well, and correct, Your Honor. If it were that word alone, then that statement alone, then perhaps we would not be able to gather enough context to determine what he meant.
Well, let me ask you this.
Please.
The officer testified that, from what I understand from the record, the officer testified that there was an abrupt lane change and there was no traffic signal used, and that there was another car in the vicinity. You agree that that's what the officer testified?
I agree that that is what the officer testified.
Was there any contrary evidence to that?
No. However, there does not need to be contrary evidence in order for a judge not to credit the evidence. In this particular
So he would
case,
have had to have found that the officer lied?
Not lied necessarily, Your Honor, but simply been mistaken or unable to make that measurement. And in fact, on page 53, the trial judge does go on to say that the officer in the situation that the officer described simply would not have been able to determine the distance based pure.
But that's only one part of it. I mean, it says I assume you're referring to the problem that I may have, maybe whether or not there really was one car length. That's the part where the court's having a problem with it?
Yes, Your Honor.
I'm not seeing anything. So do you agree that there's really no question the court's not taking issue with the officer saying there was no use of the turn indicator?
No, I don't. I do not agree with that, Your Honor. I believe that.
Is there some statement by the court where the court specifically takes issue with testimony regarding the turn indicator?
There is not an instance where the judge says expressly that he does not believe that the officer could have seen or did see the absence of a turn indicator. However, the statute requiring signaling does specifically say that not only that it is not just illegal ever to make a merge without a turn indicator, but specifically, and this is ARS 28754A, that one must use that turn indicator in the event that other traffic may be affected by the movement. And so when we have the judge's express determination that the officer...
Are you, in making this argument, are you saying that the court was saying, I find, based on all the circumstances, that you didn't prove that a civil traffic violation was committed, or, which I believe is the standard, was there reasonable suspicion of this officer? Because they're two different things, right?
Well, and they are two different things, Your Honor, and certainly the court doesn't have any express statement as to that regard. And additionally, there is a difference between proving that a traffic violation occurred or simply establishing reasonable suspicion. However, I do believe that the court is saying that there was not reasonable suspicion here, that there was not reasonable suspicion to establish that an unsafe lane change had in fact occurred. And the court, we can point to specific instances where the court believed that the court expressed a belief that the stop was pretextual, and of course...
we don't care about that, do we?
No, in the sense that as long as there is an independent basis...
as long as the officer has an independent basis or reasonable suspicion to make the traffic stop. And that's what I'm asking. Was there any contradicting evidence from the officer testifying that this is his belief? And with that belief, would that be sufficient?
And that's what I mean with the pretextual stop, Your Honor, is that while if there's an independent basis, a stop may be allowed. What I believe is happening here is that the court is looking at all these other factors that imply that it was pretextual, saying that the officer could not have at that distance made the measurements that he was asserting in court, and therefore that casts doubt as to the legitimacy and veracity of the officer.
But casting doubt, it seems to go to this ultimate question of whether we could convict him of a traffic violation as opposed to reasonable suspicion. When it says the testimony at least suggests, that seems the opposite of a finding that I disagree, or I'm finding that this officer absolutely could not have made that determination, which seems like you kind of need to make to be able to say there was not reasonable suspicion to pull him over, as opposed to, at least that's the way I'm reading it, at least suggest, gee, I don't know that really was a traffic violation. There's at least some testimony that suggests that it was not. But that doesn't seem consistent with a finding or an express finding that there was not reasonable cause to pull him over.
And I would point to, again, the closest thing that we have to an express statement from the court is, of course, our triple negative statement, where he says that he doesn't disagree that the officer did not have the ability to pull over. And what that plain language means when you parse through it is that he doesn't disagree, or he does agree that the officer did not have an ability to pull over Mr. Rodriguez. And so
in context, doesn't that look like it's kind of a misstatement?
No.
With all the rest of the, so you read it as getting rid of the double negatives the way that it actually reads. I agree that if you follow it exactly, he's saying, I agree that the officer I don't really disagree that the officer didn't have an ability to pull over Mr. Rodriguez for a traffic violation.
Correct, Your Honor, and I believe that in the context of everything else that he's saying, he's going out of his way to express all of the problems that he has with the officer's testimony regarding whether there was an actual violation observed. And then for
Except, isn't that the end? If he had really made the statement that, hey, I don't believe the officer, there was not reasonable suspicion, then he doesn't need to go on and make any other findings, does he?
Well, he would not be required to. He could have ended everything
Right.
there.
So the fact that he went on to make other findings at least suggests to me that, in fact, what he's saying is the, once you read out the double negatives, is, okay, I don't disagree that there wasn't enough for this officer to make this stop, so then I'm going to go on to the next step.
Well, I think, Your Honor, that he very well may have been simply trying to make a record of his issues with the remainder of the case as well. That the fact that he decided to do that doesn't, he's not precluded by law from additionally opining on the other aspects of the case. And so even though it was not necessarily required at that point, I believe he was simply making a record of his significant problems with the other aspects of the case. I think that there is, while perhaps not the most clear statement, there is a statement by the trial court that he does not believe that there is reasonable suspicion, that there is not evidence to support reasonable suspicion, and therefore that the stop itself was invalid.
And that's the clearest, is the, I don't really disagree. The other, you're saying the kind of the summary or other language from the court that points us in that direction, where he's disagreeing that there's reasonable suspicion regarding the turn indicator.
Yes, and to that I'm referring to, for example, where he says that he has problems with the stop and that the officer would not have been able to tell the distance that the officer was testifying to on page 53.
I'm just reading that as going to the length of following. Is there something that goes to whether there was a turn indicator?
And regarding the turn indicator, again, unfortunately, that's not something that the court expressly says. However, given the remainder of the context, it seems that when the judge is describing all of the reasons that he does not believe that the officer identified a stop, if he was then going to about face and say that, yes, but there is a valid stop, then the same absence of his comment on the turn signal would imply that he would have said, but if there was no turn signal, then the stop was valid. There is no such statement by him to contradict all of his other statements where he expresses doubt on the officer's testimony. And so there's nothing in the record to suggest that the judge believed anything other than what he expressly said, which, confusing though it was, is an express statement that the officer did not have reasonable suspicion. And again, regarding the turn signal, I believe that the trial court has expressly made the finding that the officer was not able to see the distance and did not have the ability to observe or make a reasonable suspicion determination that the car had affected other traffic in a way that's required by the statute.
I think it's a two-part inquiry. One, did it affect traffic? Two, was the turn indicator on? I don't see anything in the record that addresses the turn indicator, and I think you just conceded there was nothing by the trial court. Is that correct?
That the trial court did not make a specific determination about the turn indicator, correct?
But if you have one or the other, is that enough reasonable suspicion in your mind to justify the initial stop?
Well, if what he had was a turn indicator violation, but by the statute, what was presented, viewed through the lens of what the trial court accepted, would not be sufficient for a turn indicator violation.
That's what I'm reading when the court is saying the testimony at least suggests that a lot of drivers try to get out of their way. He seems to be accepting that, well, gee, there were other cars, but this driver is just getting out of the way of the police officer. He doesn't seem to be saying, he's accepting that, okay, there was something, but this looks like it wasn't unreasonable. But that again doesn't go to, that's not a statement that I don't believe the officer that there were cars around. It's just, gee, there's some evidence that would support his argument that I can't be convicted of that, as opposed to the officer didn't see cars nearby. When I read that, it suggests that that's the reason he pulled in front of these cars.
And my reading of that, Your Honor, is referring to cars in general, other cars, other days and times, other officers, that cars in general might want to get out of the way. I don't believe that that's a statement discussing whether there were other cars around. And again, the mere presence of other vehicles itself still does not satisfy the statute regarding the use of a turn signal. Now, obviously, in this case, there were more issues that were decided, as noted, by the trial court, and more issues, more violations at issue in this case. But in summary, I do believe that the trial court makes the express statement that he does not believe that there was a basis. And I think that that is consistent with statutory requirements for a traffic violation. However, this court also asked the appellant regarding does nervousness matter, and does it matter whether he withdrew consent? There was some discussion of whether it was a prolonged detention, and I'd like to address that as well, because in this instance, all of the questions that counsel for the appellant referenced regarding the presence of drugs, all of those occurred after the traffic stop was concluded, after Trooper Callister presented the warning, at which point the entire purpose, the entire reasonable suspicion regarding the turn signal has evaporated and no longer provides any justification for prolonged.
Do we know how long it was from time of that he pulled over to the time when?
No, we don't. I think that we can. I'm sorry. I think that it's probably reasonable to assume that it was a short amount of time. However, the amount of time is not the only factor to consider here, and specifically in this situation,
an important factor.
In some contexts, it can be an important factor. I believe that here it's completely overridden by what happened in that short amount of time, which was essentially a custodial interrogation regarding the presence of drugs. Certainly.
But how about if, let's just assume you hand him back his license and say, I'm just going to give you a warning this time for not turning on your turn indicator. By the way, do you have any drugs in the car? Is that an improper question? Is the officer not permitted to ask that question?
I believe that's correct, Your Honor, because this is not a situation where an officer is...
What's your best case to support that statement?
Well, the best case would be Rodriguez v. United States, which is, of course, a drug sniff case that...
Well, but in that case, they held that particular person for a long period of time while they got the dog there.
Correct, Your Honor.
I'm sorry, what's your best case scenario for, here's your driver's license back, and do you have drugs in the car?
So there's not that I'm aware of a case that expressly says that in that instance you may not ask further questions. We have to look to Fourth Amendment law about detentions, about stops, such as Terry v. Ohio, and other such cases cited in the brief, for the proposition that while an officer may approach someone and ask questions in a consensual manner, the standard is for whether a question is appropriate, the standard for whether it is a custodial interrogation in State v. Wyman, I believe, is whether a reasonable person would feel free to leave, whether an average reasonable person would feel free to leave. And in this situation, he had been stopped, and he had been presented a warning, and in the same process that he's being presented the warning, he's being asked additional questions. There's no reasonable person that would view that as the officer telling him, you are free to go, you don't have to answer these questions, you don't have to.
So doesn't he ask, do I have to consent to a search?
Regarding the consent, yes, he does. He doesn't ask whether he's free to go or whether he has to answer those questions.
So does it matter in your analysis if he's got the warning in his hand, before he hands the defendant the warning, he says, do you have any drugs? Can I search your car? And then hands him the warning. Does that change your analysis?
Well, and if the facts were different in that way, perhaps we'd be having a separate discussion with separate cases as to whether he was prolonging the stop itself. But yes, it does affect the analysis, because that is a clear demarcation point, at which point his reasonable suspicion is gone for the traffic violation. There's no way to argue that anything that happened after that point had anything to do with an alleged bad merging. And so that act is a pretty clear, bright line of the reasonable suspicion stop being over. And so prolonging that stop, even for a short amount of time, in order to ask questions of a subject who is being detained for no reason because he would not have felt free to leave, that's where the violation occurs. And it does not...
What I'm hearing you say is that when a police officer stops an individual for a traffic violation, that individual officer can not ask the motorist any other questions except for as it relates to the traffic violation. Because if they do that, it's a custodial interrogation.
No, Your Honor, I would disagree with that. I think that would be too broad of a statement.
Okay, so
for what
let's
my
narrow it
argument
for
is.
me. If he asks the question about the drugs prior to handing him the traffic citation, and that goes to Judge Campbell's question, I think is why she asked it. Mm-hmm. Is that okay?
And I do think, Your Honor, that at this point that would be consistent with case law, although I do believe, having reviewed for this argument, that there would be a basis to potentially argue, depending on the nature of the questions and how long it prolongs the process.
Just one question, though. Do you have drugs? I'm just outside the door. I haven't handed you and it is prolonging me handing you the warning. And it doesn't seem like it's prolonging it any more than I hand it to you and then say, by the way, do you have drugs?
And if that happened during a reasonable suspicion traffic stop, that would at this point be a fair line of questioning. In this case, of course, it wasn't just the one question. It was several. And it was, unlike in that hypothetical, after the clearly demarked end of the reasonable suspicion stop. And so that is problematic. And it doesn't matter the length of time in this case. Some of those other cases, such as Rodriguez and others,
talk. So the clear line that you're drawing is, so if we're assuming there was reasonable suspicion to pull him over, what's the clear demarcation?
When he hands him the warning at the end.
And then that's it. Okay.
Correct, because at that point, Your Honor, there is no reasonable step in the process that has to do with the actual traffic stop. There is nothing else that needs to be done at that point. It doesn't matter the length of time that series of questions took. If the questions themselves are inappropriate because the subject would not feel free to leave, then it doesn't matter how many questions were asked or how long the person was detained at that point for questioning.
I thought time was relevant. And I thought in Rodriguez they talked about it. Time that was not only relevant, it was an important factor to consider.
The facts in Rodriguez were different. Time in that case, it was time sitting in his car waiting for the canines to come and do a sniff. Time is not significant when superseded by a line of questioning. Our argument is not that he was detained for too long, but that he was unfairly detained for custodial interrogation.
But if we took it, then time wouldn't even be a factor in Rodriguez at all, because once the traffic citation was administered, whether it was a second or 2 hours to get the canines there, it's still a violation.
And speaking of time, Your Honor, I see that I'm out of it. May I answer your question?
Sure,
yes,
please.
you may complete your answer.
The distinction in Rodriguez is that their argument was that it was a violation because of the time alone. Our argument is not based on time, but rather what happened in that time, specifically the custodial interrogation.
Before you sit down, sorry to prolong it, but if officers just have a roadblock and someone drives up, is there some reason why they can't just say, "Do you have any drugs in the car"? Even though there's no reasonable suspicion of drugs, but they're just there and they ask the question.
A roadblock, not like a checkpoint, a traffic roadblock?
It could be traffic roadblock, checkpoint, whatever it is.
I think that would very much depend on the nature of the checkpoint. But the distinction in this situation is that from start to finish, this was not a consensual situation. This was a forcible detention based on reasonable suspicion. After that reasonable suspicion evaporated, it did not become consensual simply because the officer was done, because based on all of the circumstances, Mr. Rodriguez would not have felt free to leave. Thank you.
Thank you, counsel. Ms. Ashley. And if you need additional time, let me know.
I just want to kind of go back to the reasonable suspicion for the traffic stop, because it's one of the main things we've been discussing. And I think when the trial court made its decision in this case, that double negative has confused everyone, and the state has taken it as that he is saying that I don't like it, but we can proceed to everything else. And as to the
but it's, if you read it literally, it says, "I don't disagree. The officer did not have the ability to pull over Mr. Rodriguez for a traffic violation." I think that's the, if you just track it through, that's what the judge is saying. I don't disagree. This officer did not have the ability to pull him over.
And I disagree with that reading.
But that's just literal.
There's way too much disagreement going on.
Yes, I disagree.
And the double, triple negatives are very confusing, but when we look at the testimony that was presented, the officer testified that he saw the abrupt lane change without the turn signal. When we're reading the statute and looking at how that's been applied previously, that traffic signal does have to be used. So we do have that, and it's like the court doesn't like that. And when it made that statement, it still continued to analyze the other issues that came up in the motion to suppress. So he's impliedly saying, I don't like this, but let's move to the next issue, which would be following distance.
Well, you give me, I can understand an argument that in context, the judge has misspoken there because that doesn't make sense with everything else that he's saying. But the literal reading of what he said is, I don't disagree. The officer did not have the ability to pull him over for a traffic violation. But that's, anyway, sorry, I'm just beating it.
I just don't believe that determination can even be made with the facts that were presented in the motion to suppress hearing. That in the record is clear that the officer observed the abrupt lane change without the turn signal. The statute and case law supports that you have to use your turn signal in order to make that lane change.
But the judge could just say, I don't believe that this officer's vision is good enough to have actually seen that.
If he chose to say that, then it would be a credibility issue, which I don't think he said in this. The trial court made that determination in this case. If the trial court determined that the officer was unreliable and possibly could not have seen any traffic violations, I think the court would have stopped at that analysis and made the ruling at that point. But even if the trial court says he couldn't have seen it, we're still moving forward in this case and in his rulings when we're moving on to the next issue that was brought up in the court. So I think the court is truly impliedly saying, I don't like that he can do this. I don't like this traffic law. I don't like this traffic stop. But we are moving to the next analysis and the next point, and that's how the court proceeds on. And also in the testimony, I believe it's on about page 12, Trooper Callister stated he told the driver the reasons for the traffic stop, and the driver actually agreed to committing a traffic offense and apologized to Trooper Callister for committing the traffic offense. So even if the court says, well, Trooper Callister is too old to see that far away, we still have the driver and the defendant himself admitting to the traffic violation. So the facts that were presented and that are in the record, it does support that there were 2 traffic violations committed in this case.
How do you respond to the argument that this was a custodial interrogation after the presentation of the citation?
This is not a custodial interrogation.
Was he free to leave?
Eventually, Trooper Callister said he believed he had enough reasonable suspicion to detain him. However, that's kind of irrelevant when we're looking at the consent issue. And I know Rodriguez was brought up, but I believe it's State v. Johnson that states that you can't measurably extend the traffic stop. And in this case, it was one question where consent was gained to access.
How many questions would be too many?
I believe it would have to measurably extend it, and I don't know how many questions it would measurably be, but I think it would have to be more than one, and it has to be a measurable time, 5 minutes, 10 minutes, however the court in the future wants to define measurably extends, but I don't believe one question measurably extends the traffic stop, and that one question gave consent to search the vehicle.
How long, from the time he was pulled over to the search, how long it was? Do you believe the records tells us that?
The record is not clear, and there is no time frame to support the entire traffic stop. The only time that's actually mentioned is when Trooper Callister states he hands him the consent to search form to read over it, and that took approximately about a minute or so. So we don't know the full time.
So your officer testified, I was turning over stones, meaning trying to develop reasonable suspicion, probable cause. Does that affect how we view the prolonged detention?
I don't believe so. He was multitasking when he was turning over these stones. He was still filling out the warning. He was still verifying that this vehicle was in fact rented and the driver was allowed to be in possession of this vehicle. He didn't stop his traffic stop violations in the warning to investigate and turn over these stones. However, from the beginning, he knew.
You're interpreting turning over these stones. I was interpreting that as looking for other, I'm looking for drugs. Am I misreading that? Turning over stones doesn't go to whether I had a basis for a traffic violation stop, does it?
No, it does not. It is a subjective motive of the officer, which we know we don't look at the subjective motives as long as it doesn't prolong the traffic stop. And in this case, it didn't. As he was filling out the warning, he was engaging in conversation with the driver and the passenger.
So you would agree that turning over stones means looking for other crimes, perhaps?
I would agree. It goes to the officer's subjective motives of the traffic stop.
The stop is already accomplished, and he's turning over stones during the conversation with the two people in the vehicle, correct?
Correct.
And so we have counsel arguing that the prolonged detention justifies suppression. The citation is delivered. Then the consent happens. Do you think that that has any bearing on whether or not the detention was justified in length and kind after the citation was delivered?
When the warning was handed over, obviously the traffic stop has been concluded in this case. And then that one question of, do you have any drugs in the car? And he says, go ahead and check. I don't believe Trooper Callister's one question measurably extends the traffic stop to even evaluate prolonged detainment in this case. The facts are one question, and he immediately gets consent to enter that vehicle. At that time, there's no more prolonged detainment, and there is a consent. There's a consensual conversation at that point, and it's also a consent to get access to the car. Trooper Callister just clarified and took it further by giving Mr. Rodriguez the consent to search form to read to make sure he fully understood. So I don't think prolonged detainment is an issue. As for everything else, I just think the court in this case erred in its rulings. Although they are confusing, I believe that there was enough facts in the record to support that there were traffic violations that occurred and that there was reasonable suspicion for those traffic stops. I also believe the defendant did consent to get into the car after the...
There are facts to support, but are there facts to support the court's a finding by the court that there is no reasonable suspicion?
I believe the court erred when it said there was no reasonable suspicion, and I don't know if we're talking about reasonable suspicion.
Did it say that
for the traffic stop?
Are we talking about the traffic? Did it? I don't see where the court said there's no reasonable suspicion for the traffic stop. Did he say that anywhere?
I don't believe he said that. I believe his double negative is what we all keep getting confused with, to be honest. And I believe the facts support that there was, in fact, a traffic violation, and the double negative has just confused everyone when we're reading through his record. But I believe the way it is written, it's enough to support that the court did find there was reasonable suspicion to conduct the traffic stop as it proceeded on to the another analysis. I would just ask that the court reverse the lower court's decision. If that's not the appropriate remedy, I would ask for a remand to have the correct facts and law found in this case. Thank you.
Thank you, counsel. We thank you both for your arguments. We will take this matter under advisement. We are at recess.